Good evening, everybody. So, the marriage bill. This is a proposed new law that seeks to update and overhaul South Africa's current marriage law system. Our marriage law system is currently quite fragmented. We have three marriage acts: the Marriage Act, the Civil Union Act, and the Customary Marriages Act. And then we also have some religious marriages which are not yet recognized. So the marriage bill follows a long legislative process. It started with the green paper on marriage, which was followed by the white paper on marriage. A white paper is an official government policy document that sets the policy for a particular sector. From that, the Department of Home Affairs produced a draft marriage bill, and eventually the marriage bill was introduced in Parliament. And we really commend the Department of Home Affairs for the extensive public engagement process that they had. Meaningful public participation in the lawmaking process is such a critical element of any truly democratic system. Before I get into the substance of the marriage bill, I do want to pause and explain a little bit about FOR SA's stance on the marriage bill, because we do get questions about this. As Michael said in the introduction, we're a legal advocacy organization. We are faith and politically neutral, and we're also doctrinally neutral. So what we do is we protect the broad right to religious freedom and related rights as protected in the South African Constitution. And our Constitution truly protects religious freedom very broadly. It protects freedom of conscience, opinion, belief. It's a broad right. It even protects the right not to believe in anything. So our focus, our mandate is to protect that broad right, to ensure that you are able to live according to your religious beliefs. And that is the lens with which we look at the marriage bill. We are aware that certain religious organizations and perhaps many persons of faith have another way of looking at the marriage bill. They might have a particular theological lens that they look at the marriage bill, so their concerns might be wider than ours. And of course, it is a democratic right to have these concerns, and we would encourage everyone to participate in the public participation process and to voice their opinions, because that's why we have democratic rights. And I will talk a bit more about the public participation process later. But I do want to say that we are aware and we do respect that people have broader concerns than our very narrow concern, which is the broad right to religious freedom. So from that perspective, what is our overall impression of the marriage bill? We think overall it's a very good bill because it broadly protects religious freedom and other constitutional rights in a very reasonable and balanced way. But unfortunately, there are also a few problematic aspects. The good part of the bill is that it recognizes religious marriages subject to reasonable minimum criteria. So reasonable minimum criteria is how old are the parties? Did they consent? Are they witnesses? Because you don't want fraudulent marriages. You don't want people being forced into marriages either. So it's reasonable to have criteria. And it's so important that religious marriages are recognized, because if you have a religious marriage and something happens like a divorce or a death, it leaves the surviving spouse and children, or divorced spouse and children, sometimes in a very bad position. So that's an important protection. Another very important aspect of this marriage bill is that it expressly protects religious marriage officers from being forced to solemnize any marriage that goes against their conscience and belief, and also that of their religious organization. This is the position in current South African law. The Marriage Act has this protection. But when the draft bill, the bill of Home Affairs, was produced, it did not have that express protection. And we queried this, and the department said, no, but that protection is implied. And we said, it has to be expressed. Because if it was there and suddenly it's not there, it might raise questions. Lobbied really hard for that. We also want to thank everybody who at that stage, in that part of the public engagement process, participated, because we made template submissions that helped members of the public to comment. And those comments were taken seriously. It shows you why public participation is very important. And that clause was inserted into the bill that is now before Parliament. And we will definitely, in our submissions to Parliament, we've already done so in our written submissions, but in our oral submissions, we will also contend that this protection needs to stay in there. Another thing that the marriage bill does, it extends the categories of persons who can become marriage officers, because you have to be a designated marriage officer of an ex officio marriage officer to actually do the legal part of a marriage. By extending these categories, so that a designated marriage officer does not only need to be a religious marriage officer, any cultural or secular organization can have their own marriage officers. Why is this important from a freedom of religious perspective? Is because if each um, organization or institution with its own particular viewpoint has its own marriage officer, if anybody then wanted to argue that um, somebody needs to solemnize their marriage or potentially force a person to solemnize a marriage that does not agree with them, you would say it's not a good argument because you can have your own marriage officer. Everybody has their own. So it also makes the chance of a person being forced. So if anybody making that argument, it makes that less likely. As I said, there are problematic aspects to this bill. And the primary concern is about the ex officio marriage officer. So an ex officio marriage officer is a person who is a marriage officer due to some civil employment position that they hold. Typically a magistrate, an official employed by the Department of Home Affairs. There are others as well, but they're the main categories. These marriage officers used to have a right to conscientious objection. When the Civil Union Act was amended, this right to conscientious objection was taken away. We will address this issue in our written submissions, or we already have. We will also address it in our oral submissions. We believe that there's a very practical solution to this problem contained in the department's own white paper, because we do recognize in South Africa is a constitutional democracy. We have diverse people in our country who believe different things and live in different ways. And the state is under a legal obligation to treat everybody fairly before the law, to respect the rights and freedoms of everyone, and to render marriage services equally to all who are legally entitled to be married in South Africa. And in the white paper, there's, for example, a suggestion that if you separate the solemnization aspect of marriage, which can have religious overtones, from the legal administrative part of marriage, you can address this issue. Because then registering a marriage is like registering a birth or a death, which can perhaps address the conscientious concerns of a lot of people who would otherwise have been uncomfortable solemnizing certain marriages. Because as we, on the ones that we have the Constitution and the human rights and the state with its legal responsibilities and duties to render services to all, we also know that in the Constitution we have the right to religious freedom. And that means that you have to practically be able to live out your faith, and you don't leave your faith at home when you leave, for work in the morning. So that's a way to balance rights. The constitutional approach should always be, how can we maximize rights? How can we reasonably accommodate everybody? Because our constitution celebrates unity and diversity, not unity and conformity. There's some other issues with the marriage bill as well, but they're perhaps technical legal issues, perhaps just oversights in texts, and that can be amended. But just on the status of the marriage bill, at the moment, it's for Parliament, as I said, it's for the National Assembly, which is the first house, particularly the Portfolio Committee on Home Affairs. They have asked for written comments. We have sent in written comments. They're busy with public hearings in the provinces. They have held public hearings in Gauteng and KwaZulu-Natal. They're busy in the Eastern Cape next week, or in the first week of April, they'll be in Mpumalanga. If you want to know about these dates, follow us on social media. We post the updates there, the dates and the venues and the times. And this is where you have the opportunity. And if you have broader concerns than ours, to reiterate those concerns, or if you have the same views as ours, you can also go and raise those points in these meetings. And once these public hearings have been completed, then also in National Parliament, we will participate in those. And then this portfolio committee needs to sit and seriously consider all the comments that were made to it. And then they decide, whether they want to reject the bill, adopt it as is, adopt it as amended. And then it goes to the second House of Parliament that should also have its own public participation process. Typically, it consists of written comments as well as opportunity to make oral comments. So if you're perhaps in a province like Gauteng and, you missed the public hearings, there's another opportunity for you to participate. But we would then encourage you to follow us on social media, to subscribe to our newsletter so that you won't miss that opportunity. But that's the marriage bill in a nutshell. Overall, a very good bill, but there's one or two aspects that we will definitely look at to improve.
Good day. This is Nobukosi Zulu, legal advisor at FOR SA. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.